The committee will come to order. After recognizing myself and the ranking member, Mr. Berman, for 7 minutes each for our opening statements, I will recognize the chairman and ranking member of the Subcommittee on Africa, Global Health, and Human Rights Subcommittee for 3 minutes each. We will then hear from our witnesses, and I would ask that you summarize your prepared statements in 5 minutes each before we commence with the question and answers from members under the 5-minute rule. Without objection, the witnesses' prepared statements will be made a part of the record, and members may have 5 days to insert statements, questions, and additional material for the record, subject to the length limitations in the rules. The Chair now recognizes herself for 7 minutes. Today we are here to discuss the dark clouds of oppression that hang ever heavier over the peoples of Tibet, Burma, and North Korea. I was proud to be a co-sponsor with our late chairman and strong human rights advocate, Tom Lantos, of the Tibetan Policy Act and an original co-sponsor of the Bloc Burmese Jade Act. I was also privileged to author the reauthorization of the North Korean Human Rights Act, which was enacted into law in 2008. Congress has long sought to address the suffering of the people of Tibet, Burma, and North Korea through legislation to ease, to some degree, their pain. Let us now examine the executive branch's track record in implementing these acts. There is a common thread that leads to a massive spider web of human rights and religious freedom violations. At the core sits China. As we commemorate the 22nd anniversary of the Tiananmen Square massacre on Saturday, we must never forget those who fell as the tanks crushed the democratic aspirations of the Chinese people. We must never forget that the heirs to this shameful Tiananmen legacy and their comrades in bloodlust continue to subjugate by the sword not only the Chinese people, but also the people of Tibet, Burma, and North Korea. Whatever the motive, a rising China is at the center of this trio of tyranny, which casts a dark shadow over the otherwise optimistic projections for Asia's future. Turning to the 3 laws that we are examining today, since 2002, when the Tibetan Policy Act first called for the establishment of a U.S. official presence in the capital of Tibet, there has been absolutely zero diplomatic progress. The State Department must make it perfectly clear to China's diplomats that there will be no more Chinese consulates opened in the U.S., not in Atlanta, not in Boston, not in Honolulu, until the Stars and Stripes are flying proudly over U.S. diplomatic facility in Tibet. It is also regrettable that the Special Coordinator for Tibetan Issues, a position created by the Tibetan Policy Act, could not appear as a witness today to address the oversight concerns of Congress with regard to this act. I now would like to turn to the Bloc Burmese Jade Act. I understand that the administration has finally put forward the name of Derek Mitchell to serve as the Special Representative and Policy Coordinator for Burma, a position created by the Act, and that he is awaiting Senate confirmation. I would like our administration witnesses to explain why it took almost 2.5 years to name this official to a key position legislatively mandated by Congress. I would also ask the administration witnesses to elaborate on the approach to the Burmese junta and if the administration remains committed to pursuing what it calls a policy of pragmatic engagement, a policy I strongly disagree with. Another key component of the Burma law was the prohibition on the import of Burmese gemstones, rubies, and jade. A Government Accountability Office, GAO, report on September 30th, 2009 stated, quote, U.S. agencies have taken some steps but have not shown that they are effectively restricting imports of Burmese origin rubies, jade, and related jewelry while allowing imports of non-Burmese origin goods, end quote. If we could work so effectively with the African countries and our allies to ensure that we could block the importation of blood diamonds during the conflicts in Africa, one has to question why it would seem that we have not made the same efforts with blocking imports of Burmese rubies. Finally, let me address the North Korean Human Rights Act. It is especially appropriate that the Special Envoy for North Korean human rights issues, a position created by the Act, is here today. We welcome Dr. Bob King, a longtime trusted advisor to Chairman Lantos and former Democratic Chief of Staff for this committee. The North Korea Human Rights Act specifically clarified any confusion on the eligibility of North Koreans for refugee or asylum consideration in the United States. While the vast majority of North Korean refugees will continue to be resettled in South Korea for historic, linguistic, and cultural reasons, the Act spells out that the U.S. doors remain open to North Koreans fleeing savage oppression. Only about 120 North Korean refugees have made it to the United States in the 7 years since enactment of this legislation. That raises questions about the State Department's purposefulness. Another issue addressed in the Act is food assistance to North Korea. The Act is clear in stipulating that, quote, such assistance should also be provided and monitored so as to minimize the possibility that such assistance could be diverted for military or political use, end quote. I share the concerns of my Senate colleagues in their May 20th letter to Secretary Clinton that any food aid provided would most likely be used for propaganda purposes to mark the 100th anniversary of the birth of the North Korean founder. It should be clear that there should be strong opposition in the Congress to any attempt to provide food assistance paid for by the American taxpayer for more bread and circuses in Pyongyang. I now turn to the distinguished ranking member, my friend Mr. Berman, for his opening remarks.